Learning objective 2, describe the different electronic document formats and the reasons for using them in litigation. Adobe Acrobat, PDF files. Very handy because someone cannot change them easily. You know, it sort of like freezes them. So they can't come in and try to add stuff to what you've already, you know, like a Word document. Someone can go in and edit and add or delete something. Adobe Acrobat can't. PDF Converter is, you know, a lot of times you might not have the software that was used to create the documents. So PDF Converter will convert it into PDF files for you, and it's still searchable. TIFF format, those are used a lot for pictures because they have high resolution, good quality, small storage size. OCR, we covered that in the last presentation. That's for scanning in documents in such a way that they can still be searchable for the terms in them. They don't just turn into a picture. Describe the electronic discovery process. Okay, it's going to cost money to do all this. And you might need multiple software programs in order to view all the originals. And paper documents may have been converted to electronic format. This can be so time consuming. And if you outsource it, it's going to be costly. So just be aware, and that, you know, you have to do a cost benefit analysis, discuss it with the client, let them know how much this is going to cost. Explain how the courts have implemented the federal rules on electronic discovery. So the two cases listed here, I put links to them in the Canvas site. The first one, you know, these are cases where even before the case has gone to trial, the plaintiffs have brought actions because they're saying the other side destroyed evidence, or because of their negligence, evidence was destroyed, and how the court punishes the other side for doing it. Zubilaki, I found interesting or kind of humorous because, you know, there's a little bit in it where some backups of emails have been destroyed. And the plaintiff feels that in those emails is evidence that she was discriminated against because she was a woman. And part of what the court says is, hey, you've already produced a lot of emails where it makes it clear your boss does not like you. But none of them seem to be about your gender. He just dislikes you. So these other emails probably are just more of the same. West v. Goodyear, it's just equipment left outside, so it could no longer be examined in part of the discovery process. Learning objective 5, explain how predictive coding technology can ease the burden of electronic discovery. Okay, this is technology-assisted review, which basically, you know, you take a small group of documents and you experiment on those doing search terms to see what they're finding for you. So it's computer programs that use search algorithms to search a small set of documents that are then manually reviewed for accuracy. And then in selecting the desired terms before the search is applied to a larger set of electronic files. So you can just sort of like, you know, have the computer do some files and then manually you go over it. And then you can say, okay, it's working. We'll put it the other 1,000 pages through it. Replaces manual examination of electronically stored documents. Small number of as we said, saves time and money. Okay, understand the ethical issues and the procedures for protecting confidential or privileged information. Remember, attorneys and paralegals have a duty to preserve the confidences of clients. So anything that they gave them that was confidential should stay confidential. But it can be difficult when there are large numbers of documents being handed over, and some confidential information may be overlooked. So there are often things called clawback provisions. And it states that if a privileged or confidential material is inadvertently disclosed, the material may be recovered, not used against them. And the legal team, for that to work, the legal team must include a clawback clause to prevent a potential claim of malpractice for not attempting to protect the material. This is definitely true in federal courts and most state courts, but not all of them. Explain the effect of inadvertent disclosure of confidential information. Okay, I posted a great video from Alex Jones's trial when a whole lot of text messages were inadvertently handed over to the other side. Admissibility of the inadvertently disclosed documents may hinge on the steps the legal team takes before and after the disclosure. State courts apply different tests, but there is no consensus and issues are addressed on a case-by-case basis. In federal courts, disclosure does not operate as a waiver if disclosure is inadvertent. The holder of the privilege or protection took reasonable steps to prevent disclosure, and the holder promptly took reasonable steps to rectify the error. And if you listen closely to the Jones case, you'll see that last step never occurred. Okay, that wraps this up. A lot of things in this chapter. Watch the videos and read the cases.